Yes, Mr.
I beg to mention item number 28. Here led by learned senior counsel A. Bora. Will not come today.
On the prayer made on behalf of Mr. A. Bora, learned senior counsel, comma, not objected to by the learned counsel for the respondents, raised it to list this matter again on
After 4 weeks.
after 4 weeks on a date to be fixed by it. Okay.
My please, Lordship, my lord, if your Lordship allows me to move and anticipatory bail, my lord, unlisted. Obliged.
May I please, my lord. Item number 31, my lord. This matter, my lord, I am for the respondent, my lord. This matter, my lord, the main suit, title suit, my lord, against which order the appeal has been filed, my lord. That title suit has been dismissed for non-prosecution by the appellant, my lord. Therefore, the matter has become infructuous. That's why, my lord.
But where is the appellant?
Your Lordship, I am for the appellant, Your Lordship.
So what is left here?
On behalf of Senior Counsel Sila Datta. Your Lordship, actually, I've been asked to take an adjournment today, Your Lordship, as he could not present today.
Or on
My lord, but one problem is that, my lord, we hear, my lord, without hearing me, this status quo order has been passed, my lord. That is the issue, my lord.
But now the suit is gone.
Suit is dismissed. But since, my lord, there is an order from the governor, then it become difficult for me. Otherwise, my lord, I have a certified copy of that dismissal order.
No steps taken for restoration of that.
No, as on today, not, my lord.
10, 12.
My lord.
Okay, we'll have it immediately on reopening. You place that on.
But then status quo may not be continued, my lord, on that day hearing, because
say tomorrow that again, that will require an hearing. We'll hear the matter. I would have been happy if you had done the matter today. What happened to him?
Your Lordship, as he informed me that due to his health problem, he could not present today.
Because, my lord, without hearing me,
I'll fix it. Don't worry. I can understand your anxiety.
Well,
nothing is left here.
Well,
a prayer is made on behalf of
Senior Counsel Sila Datta.
Mr. S. Dr. Learned Senior Counsel for an adjournment in the matter today. Item number 31. Full stop. However, Mr. R. Sona, Learned Counsel for the respondent, submits that the title suit from which the present title suit, that the connected title suit pending before the trial court has been dismissed for non-prosecution by the trial court by order dated 10/12/2024. However, it is submitted that FI further submits that the status quo order as operating in the present proceedings has caused prejudice to him. Full stop. However, considering the fact that the prayer is made on the health grounds of the arguing counsel, this court accepts the prayer for adjournment and directs that the matter be listed on 7/1/2025. It is provided that no further adjournment in the matter would be granted. 7/1 is fine, Mr. Sona?
fine,
Highly obliged.
much.
Yes.
My lord, I like to mention one miscase for orders today, my lord.
Wait.
My lord, this matter was come up before the court number 1 yesterday, but court number 1 has directed the registry to place it before the appropriate court, my lord.
What is the issue?
My lord, this miscase is regarding restoration, my lord. My writ petition has been dismissed for non.
By this court?
Yes, my lord.
Oh, good. Get it tomorrow morning. Tomorrow. First time. Tomorrow. Because we may have to rise early today.
Only time permits, my lord.
Why you take it's only restoration?
My lord, my interim was also vacated, my lord. That's why, my lord.
Get it before 2.
My lord, it's already filed, my lord. It's all listed before the court number 1 yesterday, my lord.
एक supplementary list लगा दो अभी.
Lordship, I would like to mention one unlisted matter. So I may be allowed to move this bail application as unlisted matter today.
BA or AB?
Regular bail.
BA?
Bail.
Tomorrow morning.
Just to issue notice. Just to issue notice.
सब एक साथ लगा दीजिए जितना जल्दी हो सके.
May I please, Your Lordship? Your Lordship, I like to mention item number 17, Your Lordship. Your Lordship, I have taken consent from the other party. Your Lordship, content counsel is currently out of state, is currently appearing for an exam. So Your Lordship may
Okay.
adjourn the matter.
On prayer made prayer is made on behalf of Mr. L. Nevi, learned counsel appearing for the petitioner for an adjournment in the matter on account of certain personal inconvenience. Prayer accepted, registry to list this matter after 4 weeks on a date to be fixed by it.
Lordship, I may be allowed to mention item number 14.
14.
Yes, Lordship.
Why?
I'm mentioning on behalf of Mr. Learned Counsel Mr. T. Time, Lordship.
Why?
Learned Counsel Mr. T. Time could not able to attend court today because of some personal difficulty. So this matter may
Prayer
be
is
discussed after 3 weeks.
on the prayer made on behalf of Mr. T. Tang, who is stated who is not present in the court today on account of certain personal inconvenience for an adjournment, prayer not objected to by the learned counsel for the petitioner. Registry to list this matters after 4 weeks on a date to be fixed by it. I've made the thing ready, but could not finalize or complete it. We'll pass the orders. Disposed of. We have only directed them to open the seal cover, and then if the recommendation is in your favor, to proceed with it. And we have also said that dependency of the appeal will not be a bar. Nothing more.
We didn't wanted something else,
But I have asked them to do it notionally, but your retirement benefits, your retirement date is?
date, Lordship. It's December 2020.
December?
2020.
So we will ask them to a date prior to your 31/12, a date prior to your this retirement, they will reinstate you. Oh, sorry, they'll give you the promotion with effect from the date your junior had retired. Notionally fix it till the date of your superannuation, and then recalculate your what do you call that, pension and pension benefits, and release the areas to you. Is he here? Mr. Patin Sahib is here. Item number 32, anybody? Let him come. Ms. Jenny, I've gone through it, but I think he has to, the grounds that has been urged, not sufficient according to me.
Yes, yes. I'll leave to Your Lordship.
The lady also, there is some exaggeration, but the main act has been reiterated in her deposition also. In that view of the matter, I feel that without I'm telling Mr. Patin, I thought not proper.
Yes.
Okay, fine. Let him come.
Okay.
May I please, my lord? My lord, we have filed IA in WPC number 359/18. As per direction being made by this honorable court on 13/12, my lord, to implead the Union of India.
You have filed 2 IAs.
Yes, my lord. 2 IA, one is in
321,
321, my lord.
and one is in 359.
Yes,
Where is the party you are trying to implead now?
my lord, I'm trying to implead Secretary Ministry of Road and
It
Transport.
will not do. You will have to implead the government. Secretary is not the government.
My lord, Secretary Ministry
Represented by the
representative.
secretary. You should put it like that. How can I accept this? This cannot, the Union of India has to come in.
Yes.
Secretary is not the Union of India, Mr. Yeah.
So, my lord, in that case, I may allow to amend the petition my IA.
But if you amend
both
it
the
here, you will
IAs.
have to amend it in the CIS also. File an additional, what do you call that?
So-
Amended cost title. That will take time.
So, my lord, in that case, I may withdraw this both IA
You
and
both
I'll
file-
press.
File.
I'll-
Tomorrow, but
Yes, my lord.
tomorrow.
Yes.
On the prayer of the learned counsel for the petitioner.
Lordship, now the petitioner is now out of the station due to some medical emergency.
Okay, fine. The present interlocutory applications have been filed by the petitioner herein by the applicant praying for impleading the two respondents. However, on perusal by this court, it is seen that the respondent number 1 has not been correctly described. So, the respondents have to implead the Union of India and not the secretary of the concerned department as a party respondent. So, in view of the above, the learned counsel for the petitioner submits that he be permitted to withdraw
Yes.
the present IA and with liberty to refile the same. IAC 254 AP 2024. Accordingly, prayer is accepted. IA stands dismissed on withdrawal. Same order in IAC 255 AP
Yes.
2024. When will you file?
My lord, after 1 week, as and when client is returned here.
The main writ petition many here 359, contempt case 15 and 321. Tino mein, ma'am? The case was heard at length by this court. However, during the deliberations, it was found that the Union of India in the Ministry of Road Transport and Highway was not impleaded as a party respondent in the present proceedings, and the further the said party was found to be a necessary and proper party in the present proceedings. So accordingly, liberty was granted to the petitioners to implead the Union of India as a party respondent in the present writ petition, in the above noted writ petitions. So, however, the IA so filed was withdrawn today. IA so filed IA number 254 AP 2024 and IA number 255 AP 2024 were withdrawn on account of defects so existing therein. Also, it is submitted by the learned counsel for the petitioner that the said IA would be that the interlocutory application for impleading party respondents in the present in the above noted petitions would be filed within a period of 1 week. So, in view of the above position, the registry to list these matters again on 7/1/2025 along with the IAs that would now be filed in the matter by the petitioners. Also, however, the present writ petition shall not be heard, that shall not be treated as a parted and or tied up matter by this bench any further. You get it?
Yes.
Thereafter, 6 months, by the time I should be here.
Yes, ma'am. Much better.
Mr. Tapin, when you get some time, go deep into it. Because yesterday also I went through it. There is a certain gray area. Because your affidavits are the misleading ones.
Oh, sir.
Can't help it. Madam, I have gone through it, but I'm not convinced. So I'll say that further hearing is required. The matter was listed today for delivery of orders. However, Madam, your name?
D. Riba.
Ms. D. Riba, appearing for Mr. M. Patil, learned senior counsel, has submitted that he would like to advance further arguments in the matter. Also, accordingly, they raised to list this matter again on when?
After.
9th?
Yes.
On 9/1/2025 for further, 9/1/2025 for hearing. Also, this matter shall not be treated as a matter and or tied up matter by this bench any further.
Deeply.
My lord, this is a regular bail application number 129 AP 2024, filed under section 483 of BNFS 2023.
What is the date of your detention?
29 July 2024. Today is almost 4 months, 18 days. 138 days.
27A.
Your Honor, other co-accused in this case already granted by Honorable District and Session Judge.
Why were you not granted?
Our one first bail application is rejected by Honorable District and Session Judge. And I already annexed. Yeah.
Heard Mr.
D. Sora, Domin Sora.
Sora, Learned Counsel for the petitioner, and Ms. L. Hage, Learned Counsel, Learned Additional Public Prosecutor appearing for the state respondents. The present application has been filed, praying for enlarging the accused Moinul Haq on bail in connection with Naharlagun Police Station case number 85/2024 under section 21 bracketed B / 25 / 27A / 29 of the NDPS Act 1985. The accused is in custody since the date of his arrest on 29/7/2024. Issue notice, call for the case diary. Ms. Hage shall on the next date produce the case diary of the above noted case. So when?
23rd, Lordship, Monday.
23rd. List this matter again on 23rd, 23/12/2024 for production of case diary.
Yes.
Right.
My Lord, item number 6, same case, same FIR, same police station, same section. Co-accused.
Or it is 6, 7.
खाली आपका नाम होगा
Yes. Applicant-
साहिरा बेगम.
Begum, yes.
मोइनुल हक का जगह साहिरा बेगम.
Yes.
इस सबसे.
Same case. Same issue.
Same.
Same.
Mustab also same? No. No. Same. ये होगा आपका
Only bail application.
असादुल मोहम्मद असादुल इस्लाम.
Yes.
वो नाम मत जाइए, वो एप्लीकेंट दूसरा है, असादुल इस्लाम.
Yes.
Item number
7.
7, Asadul Islam.
Only bail application number is different. 129.
Same day of arrest.
Yes. Only from Nalagan police station, only just 8 kilometers away from this honorable high court. Yes. Obliged.
Now even 8,000 kilometers is nothing. We have online everything.
Obliged.
That's typically bail application. Lordship, in this case, kindly see the FIR. Actually, this is a contractual disputes in connection with sale of vehicle. In fact, there was a three-party involved in the case. One is Tata Motors. This complainant has purchased 5 trucks on loan by bank finance. And accordingly, as per this statement of the complaint, this accused person, he could not pay this monthly installment. That is why this Tata Motors has persuaded him to. The complainant told that this Tata Motor company to sell the vehicle on finance. So accordingly, he was contacted by this Tata Motor banking pool. So he purchased 2 of the vehicles. There was a 5 vehicle. There was a dumper. Out of the 5, he purchased the 2, but all of the vehicle has been sold out by the Tata Motor company, whereas he has paid. He has paid as on the 24 lakhs plus. But without his allegation is there that without his permission, the vehicle has been sold. Whereas I have not sold a vehicle, but this complainant himself, this is a completely misleading FIR against me. 2 Nivas Thakur and 1 person who has already obtained this anticipatory bail from this honorable court.
Same
Mr.
case.
Yes, Mr. Nivas Thakur. I have enclosed the copy also. Babul Ali and Nivas Thakur. AB number 127. This Nivas Thakur and Babul Ali has purchased the vehicle from Tata Motors. And this the complaint allegation of the complainant is that this Mr. Mustaf Ahmed has sold my vehicle, whereas I have purchased, but it was yet to be transferred is in my name, because as per this contractual agreement, it was told that when the dumper, that the vehicle is transferred in my name, some of the amount was supposed to be 3 lakhs plus was supposed to be paid to the complainant. But before that, after receiving 27 lakhs, he sold out the vehicle to this Nivas Thakur and Babul Ali through this Tata Motors agent.
Just one.
This is the issue here involved in this case. Completely a contractual matter, civil liability. There is nothing as such this section 420 is involved.
Yes, madam.
There is nothing.
Lordship, this is a connected case, Lordship, wherein this Nivas Thakur and the Bablu Ali, Lordship, earlier they have granted bail by this honorable court, Lordship. And Lordship, after that, Lordship, on Lordship, dated Lordship, 2 days before Lordship, they have filed IA before the court one Lordship, before the justice that they want to modify the order, Lordship. That
Why?
the Lordship, as per their Lordship contention, that vehicle is in the Lordship, some the condition is not good, so they could not produce before the IO Lordship. So that is pending before the Lordship, court one Lordship in the IA
We'll send this also there.
Lordship. So the club
The
together,
club
yes,
together.
Lordship. And more
Because it cannot come to me because that why it is not noticed when from the same FIR,
Yes,
a
Lordship.
particular court has passed an order. Then it is stated in the bar that that bail applications arising from the same FIR as involved in the present proceeding has already been considered by a coordinate bench of this court. Accordingly, registry is directed to list the matter before the same coordinate bench. What was that notification number?
But I'll produce it later, Lordship.
You can have it
Lordship.
in terms of the notification dated so and so, number so and so, dated so and so.
Tomorrow, Lord.
That I don't know whether the registry will list it.
Much of that, Lordship.
My Lordship. Lordship, this is the application for the quashing and setting of the charge sheet number 95 to 2021 and FIR number 221 20 is connection with the 498A IPC against this response petition number 2. And Lordship, this is the case of this 498A. The both petitioner are the husband and wife. Earlier, the case was registered against this petition number 2, being FIR lodged by the petition number 1 in connection with the 498 and the physical assault 323 IPC. This is the FIR, Lordship, FIR.
Where is your settlement?
Yes, Lordship, this settlement is the case number 57, Lordship. Annexure number 4. This is the mutual settlement by the both parties. On the 18th September 2024, 3 months before they have settled the matter, and the both party want to pass this FIR and charge it. And the case is being
From
pending.
when are they living together? After the incident of 2017?
Now they are mutually, they are staying separately, but there is
Issue notice heard, Mr.
Titamin.
Hitami,
Yes.
learned counsel for the petitioner, and Ms. T. Jimmy, learned counsel for the learned additional public prosecutor appearing for the state respondents. Issue notice, no need to call, everything is here only.
No, Your Lordship, it seems the trial has already started, Your Lordship. They
Yes.
have already taken the statement of some witnesses.
You wanted trial court records.
Yes.
Also, registry, issue notice, returnable 4 weeks. raised to requisition the trial court records of GR case number. Or is it before GR case number?
243 of 2021.
243 of 2021, presently pending disposal before the court of the learned chief judicial magistrate, Capital Complex at Impia. Full stop.
Any of this?
Lordship.
This one. My lord, this is joint application under 528 of the BNSS filed by both the informant and the accused as a petitioner number 1 and 2. In connection with my lord, PS case number 8 and 11. Initially, my lord, the FIR was lodged by the petitioner number 1 against the petitioner number 2, which has been registered as
He is the police officer.
my lord, both we are the my lord police officer. The applicant petitioner number 1 is a head constable and the petitioner number 2 is ASI, my lord. The first FIR has been registered as a Kimin PS case number 8 under section 332, 352 of the IPC. And in out of the same incidents, the counter FIR was filed by the petitioner number 2, which has been registered as a PS case number 11 under section 341 and 323 IPC. And accordingly, my lord, we have settled the matter outside the court, and thereby we have conducted the settlement agreement between us. Now we have decided not to pursue either of the PS case number 8 or 8 and
There are
11.
cross cases.
My lord. So my lord, may kindly see the first FIR in page number 12. In page number 12, my lord, got it in page 12.
Yes.
Yes, may it please your lordship. Your lordship, the first FIR was registered on the day of incident, and second FIR, your lordship will find the noting of the IO that as per the order of the JMFC. So it was initially perhaps not registered, but they have
After
filed
around 2 months.
yes, after filing
Around
for
two.
the this concerned
Okay.
magistrate, it was directed. That means there is a
Charge has not been filed.
no, it's investigation is there.
Okay.
Now, second issue is your lordship. There is a your lordship allegation of bribe, your lordship.
That's
Whether
what-
it is 10 rupees, 20 rupees, bribe is bribe. Your
Bribe
lordship.
is bribe.
So
This
if
is
it
not a case for, and if he has leveled a wrong allegation,
yes,
he will face the music.
yes.
But this is not a case for quashing, mister. That right thing has to be. What do you say? Dismiss it or issue a notice?
My lord, let
Or you withdraw?
let the my lord notice be issued. So far, my lord,
What purpose will? Sorry.
first case is concerned, my lord, the FIR, the
No,
charge
first
sheet
case,
has already
no, no.
submitted.
If you have to quash, it both have to go because this is not a case filed on merits. It's a case filed on compromise.
Yes.
Both will have to go. But in the second FIR, there is an allegation of 200. Right.
200.
That has to be investigated into.
And your lordship, later on, if material found, the PC will come, your lordship. Prevention of corruption, Act, your lordship.
What do you say?
So my submission would be, my lord, since the both the parties has already settled
No,
the
but
matter.
the allegation of 200 rupees bribe in the, that was, I was trying to find out in the, what do you call that, settlement deed. It is not even whispered that that was a wrong thing. It was a wrong or an exaggeration made.
Yes, Your
It's not there.
So my submission would be, since the possibility of convicting the accused when both the parties are ready to.
That will come when the trial is there. But today now it's investigation and 200 rupees. And if I have to dismiss it, I'll have to record. And if I record, the police is bound to
Yes,
look into that point. Why are you inviting me to cause more trouble to you? Wait till the FR, get a final form submitted. Both are police officers. And if it goes to the court, you know what to do. But here, with this one line, he demanded rupees 200 as bribe. What do you say, Mr. Modi?
Sir, my lord, in case of the first case, the charge sheet is already filed.
Charge sheet filed.
Yes.
And what about the second?
Second,
Then
PS
we'll
case number
call
11.
for the, we'll call first
Yes.
we don't want.
Let the record be called.
But I'll say that what is the material with regard to this demand for bribe?
Yes,
Then
sir.
I'll make an observation.
I'll also have to further contact with it.
You contact,
Because of,
we'll adjourn it, you contact. And then in this case, don't proceed. It might cause problem to you. What do you say?
my lord, my submission would be let the notice be issued.
I'm not satisfied.
Since the charge sheet in the first one is
First
already
one, we are not concerned.
is filed. And
I am
second-
concerned with the
second one is-
amalgamated charge sheets. Both, because both are under challenge, not on merits, on compromise. I'll have to consider both. On the prayer of Mr. C. Modi, Learned Counsel for the petitioners, not objected to by Mr. T. Ete, Learned Counsel, additional public prosecutor, raised it to list this matter immediately on reopening after the ensuing vacations.
Much obliged.
Mayor, please.
Hmm.
For the petitioner, I'm praying for withdrawal of this case
Why?
because this matter has now become first.
Mr.
B Mandal.
B?
Mandal.
B. Mandal, Learned Counsel, B or D?
Vijay.
V. Mandal, Learned. You're a party, huh? V. Mandal, Learned Counsel for the petitioner submits on instruction that he be permitted to withdraw the present criminal petition on the ground that the same has become infructuous. Prayer is not objected to by Mr. G. Tadu, Learned Additional Public Prosecutor. Full stop. In view of the above, the criminal petition stands dismissed on withdrawal.
Obliged.
Yes, Mr. Finding.
Challenging my lord, various orders, my lord, our submission are all nullities. The initial order itself.
It's a nullity. So the consequential thing,
Consequential orders are also.
we'll hear it. Heard the Learned, pleadings are complete.
Yes, yes.
Heard the Learned Counsel for the parties. It is submitted at the bar that the pleadings are complete. Accordingly, registered to list this matter. Accordingly, admit registered to list this matter for hearing in the 4th week of January 2025.
Yeah, please, Your Worship, this item may be passable for some time. Your Worship.
What happened?
Uh,
Nobody is
the
there for
conducting
the
counsel, she is engaged in court one. Your Worship.
Yes.
Lord, is it item 13, my lord?
No, 13.
Your lordships wanted my response
to that
page-
calculation.
Page
Page 70.
17. Yes.
Hmm.
I'll just clarify, lordship, that there is nothing new in that here, in this page 17. if your lordships kindly consider that page 17 for a moment, it will show that
Give me that.
they did not include any increment from 1993 to 2019. I'll just show. And there is another mischief done when there was nothing against me. Affidavit filed by respondent number.
Annexa E.
Yes, madam. Respondent number
24/11/2020.
Yes.
What happened?
If your lordships kindly come to this second column, implementation of the fourth pay commission. The pay scale was 825-15 900 EB 20 1200 per month. Now my lord will come to the last column of this chart. After adding increment as on 1/10/1992, my basic pay came to 1000. Now suddenly on 1/10/1993 they reduced my basic pay.
Why is this reduction?
Nothing has been said. Because I was placed under suspension on 6/11/1993.
6/11.
As on 1/10/1993, there was nothing against me. I was not even placed under suspension. This is one mischief. Second, they say I was placed under suspension from 6/11/1993 to 17/11/1993. I resumed service on 18/11/1993. Now,
2019.
Yes. The fifth pay commission implemented on 1/1/1996. The pay scale corresponding given was 2750 70 3800 75 4400 per month. Now, as on 1/1/1996, they have fixed at 2890. So the increment calculation is not there that they have done in the previous chart. So no increment was included. Then my lord will kindly say state government enhancement, the pay scale of constable from 2750 4400 per month to 3050 4590 per month, right? Order dated so and so. It was
but they kept you in 2890 3050 initial thing they gave you.
Exactly. So thereafter, pay fix as on 1/6/2005 3050. No increment added. Then my lord will kindly come. 6 pay commission was implemented. Last 3 lines. His pay raised from 3050 to 3150 as on 1/1/2006. Then his pay has been fixed in 6 CPC as on 1/1/2006. 5,200, 20,200 plus 2,000 grade pay. Now my lord will kindly see pay should be fixed as on 1/1/2006 6060 2000.
What is the pay of your colleagues in the corresponding rank fixed? Any material?
Lordships, the pay and grade pay will be same, but the thing is that increment will be included, and whatever was the basic pay as on 31,
that will go up. Your stage, you have been fixed at 6060 stage. You will go ahead.
Exactly, my lord. After calculation of the increments, inclusion of the increments, my basic pay will be changed, and that
now
basic
you see another thing.
Yes.
This pay fixation has been given to you as of as 6060 on 1/1/2006.
Yes, my lord.
Now you come to page 18 when it
Yes,
was after 10 years when
Yes.
the 6 CPC had come, 7 CPC had come.
Yes.
They have taken it
Exactly.
6060 plus.
That means no increment, my lord. So this is nothing but what?
No, this is no, that exercise is not done.
That exercise was not done, my lord. The calculation of increments into my basic pay, that was not done, my lord.
Okay,
it's the same thing.
We'll ask them. Where is
Lordship will kindly, my humble prayer, Lordship will kindly clarify one aspect. The headings, like my increments, revision
No,
of
no, no,
pay,
we'll ask them to redo this matter and place it before this court.
lordships,
That will
lordships,
happen.
lordships.
Nothing. The only thing is that we'll ask you to redo this order because you have not redone it in terms of the orders passed by the disciplinary authority. Oh, sorry, appellate authority. Just redo it. Who is appearing?
Miss G.
JT. Okay. We'll ask them, we'll give them some time. We'll ask them to redo this exercise. We will tell them to calculate the increments also.
Yes.
And a new order fixing your pay and allowances be placed before this court.
Revising the pay as well as they will also include the benefit of ACP and MSAP, Milord. That is also
Everything by treating you as a normal employee, whatever benefits flow to you, they will give it to you, and then they will place it before this court. Then we will close the matter.
Yes.
Item may be passed over.
Pass over. Mr. Das, you need not be here. We will. She is not here. When she comes, we will pass the order.
Much obligement.
I'm not disposing it off. I'm keeping it. I'm requiring them to pass an order in terms of the appellate authorities.
Fine, my lord. Fine. Deeply obliged.
When she comes, just tell us.
Lordship, in fact, this matter would require some detailed hearing. I believe the lower court records have been summoned and they have been received by this honorable court.
Let's come.
Please, Your Lordship. Your Lordship, that in this matter, the challenge is against the order passed by the learned session judge, that is 12/10/2023. That is at page number 21.
Item number?
Item number 15. Heritaji versus.
Mr. Tama, you are appearing? Why not? What else? Okay, we'll hear it. When?
Post lunch.
Today not possible. Because I'll not be here. I'm here only till tomorrow. Not be here.
I've traveled for this matter all the way from Delhi.
When?
Because it's up to them. Otherwise, Your Lordship, it's a very small issue, Your Lordship.
But too tied up. Many matters.
Okay. Maybe after vacation then.
After vacation, Your Lordship.
When? Give me a date. You are coming from outside. It's against the 145 order they had gone up.
Yes.
Please, Your Lordship.
145 order, Your Lordship.
That is good.
The order, Your Lordship, is this matter was come before Your Lordship earlier also. Your Lordship has also found that the learned magistrate has properly passed the order, Your Lordship, and given them the direction that remedy is before the civil court where.
Go there.
Yes.
Okay. Argue. I remember. Argue.
Please, Your Lordship. Your Lordship has stated that the present issue is for the interpretation of section 145 of CRPC. 145, Your Lordship may have section 145.
Come to the facts, Mr.
Please, Your Lordship.
Your name?
My name is Chetan Joshi.
Okay.
Please, Your Lordship.
What is the error in the order?
Error in the order is that, Your Lordship, this is completely a private dispute between two individuals. The power under section 145, as per the judgments of the several high courts, that could not have been exercised in this matter, Your Lordship. And because of that, Your Lordship, there is a stay that is operating, that is in perpetuity till today. Your Lordship may have page number 138 for the time being. Page number 38, Your Lordship. That also encloses the entire facts also.
Hmm.
The hearing arises from a notice served to Mr. So-and-so, that is respondent number 2, dated so-and-so, directing him to attend in person to answer the allegation of trespass, damage of property. So here there is only respondent number 2, which specifically discloses that this is a private dispute of property and illegal encroachment of the residential plot of one Mr. Heri Taji at Hilltop Colony, ESS sector, Intanagar. The particular land dispute has been ongoing for the past many years, and proceedings have been initiated and redressal of the grievances to FIR and MEL arbitration without any concrete outcome. As the dispute is civil in nature, relief in the form of right to title over the said plot of land may be sought from the appropriate civil court. Here also the learned executive magistrate finds that this is entirely a civil dispute, and that is between two individuals. Here, your lordship, the section 145, as it states, it is between two, not between two individuals. It has been between public at large. It cannot be between two individuals, your lordship. That is my primary argument. However, in order to preclude any breach of peace, it is deemed appropriate to invoke section 145. Your lordship, there has to be a police report. Section 145 says that if there is between two public at large, then only section 145 can be invoked. Your lordship, it is between two private individuals, as both the complainant and the respondent, with their counsels and spokespersons were present, statements were all obtained, which can be summarized as below. The complainant, Mr. Heri Taji, claims to have been gifted a plot of land.
What is the error in this order 38?
The entire.
He has not done anything. He has said that it's a civil dispute. Go before the civil court. Then
No, your lordship, at last, your lordship would say, in consideration of all the statements and documentary evidence, it is deemed that right to title may be decided by the appropriate civil court. Mr. Heri Taji has been in possession of the plot of land where his residence stands. The rest of the plot may be kept unencumbered and status quo settlement.
what is your right to the other plot of other
Your
plot?
lordship, I have been residing. I have been.
Your
in
house has
plantation.
been kept. Your house has been kept as it
In
is.
the other plot of land, your lordship, I have been doing my cultivation in the other plot of land.
Where is your pleading to that effect that the other plot of land also is there?
Your lordship, for that.
And the deeds and all, how it has come, give deed, those are all subject matter of.
Your lordship,
Why
that's
go and institute we'll say that these orders, what are there,
Your
would be
lordship,
subject to the final of other orders that would a civil court would pass.
Today, no civil dispute has been initiated by any of the parties.
You go and initiate.
Your lordship, the entire trust would be upon me then to produce each and every document.
Naturally, because you have raised the dispute, you are claiming right title over the land. Establish that. I heard this matter, I suppose. Yes.
Your lordship would see the one of the judgment which has been placed.
Forget the judgment, we are in the facts.
Please, your lordship.
Where was the occasion for exercise of 145 here?
Your lordship, that my entire submission, there was no occasion for the learned executive.
You went before the court.
Your lordship, that
Yes. You went before the court, Mr.
Yes, please, your lordship. That
Heard
was
the
a,
learned counsel for the parties at length. Heard the learned counsel for the parties. I'll be discussing it. Heard the learned counsel for the parties as prayed for. Raised it to list these matters for hearing after admit the criminal petition for hearing. Is there any interim order here? No.
no.
Admit the criminal petition for hearing. Raised it to list this matter for hearing in the month of February on a date to be fixed by. Or you're coming from outside, you can give me a date.
Your lordship, can I give it to the court also?
On February month list for hearing as agreed to by the learned counsel for the parties, list this matter for hearing on so and so. Mr. You invite the trouble and now
Your lordship,
you want to.
this was
This is a fit case for imposition of cost.
Yes.
Your lordship, in fact, this was an improper advice that has been given to the client, in fact.
Then you invited the trouble. You withdraw this, I'll give you liberty, file civil suit. I'll even make an observation that the observations and conclusions reached by the JMFC and the court will not bar you. I'll make that also. You make a mention now, I'm giving it to you.
Your lordship, can it be in February?
No, today. You make that mention.
No, your lordship, I have to seek instruction from the client. That I cannot do. Your lordship, as of now.
Because your lordship,
Anyone.
for 145 proceeding, they have lodged in
They
complaint.
approach.
Yes, they have lodged.
I will
complaint.
satisfy your lordship in February. I will
And
satisfy.
now they are saying how magistrate has.
Don't worry, I'll be here.
Yes, please, your lordship.
Okay, fine.
Only exercise.
Yes, madam, you're not filing any affidavits.
I have filed affidavit, lordship. Is it?
Oh, that case, yes. Yes. Yes.
Yes, my lord, lordship, I have brought some cases. My lord, the first case is Universal Shampoo General Insurance Company Limited versus Suresh Chan Jain and another 2024 9 SSC. Lordship, this
See,
paragraph 39 is the operative part. Lordship, here against the order of the National Consumer Dispute Redressal Commission, the Supreme Court, the Honorable Supreme Court held that 227 is mentionable. It can be filed under.
understood. That is an adjudicating body. But whether that same thing can be applied for a State Information Commission. It's not an adjudicating body. Yes, Mr. Pani.
And Your Honor, there is another case also.
Mr. Pani. Whether a State Information Commission would be an authority and over which we can exercise superintendence under 227.
Is still informed under 227? I don't think so.
I have my serious doubts on that. Because see,
226 maybe.
226, welcome.
My lord,
These consumer protection forums are basically law clarifies D. Basically, they are judicial adjudicating bodies. Yes, madam, what do you say?
My lord, I'm relying on Namit Sharma's case. Although this issue has not been specifically dealt with, but in paragraph 77 of that case, it has been said that since there is a finality in the order.
226 will.
Yes, to those. So therefore, may I read, my lord? Under the scheme of the 2005 Act of 2005, in terms of Section 5, every public authority, both in the state and the center, is required to nominate public information officers to effectuate and make right information more effective, right, by furnishing the documents, information asked for it under the said information. Lordship, I'm skipping this. I'm coming straight to the mid part, Lordship.
77.
Para 77. From the bottom, fifth line from the bottom.
Legislature.
Yes, the legislature in its wisdom has provided for 2 appeals. Higher the adjudicatory forum, greater is the requirement of adherence to the rule of judiciousness, fairness, and to act in accordance with the procedure prescribed in the absence of any such prescribed procedure to act in.
This is the answer.
Lordship,
This is the answer. See para 77 last line. This is in respect of a commission, State Information Commission.
Yes. Also, Lordship, I would like to add one more thing, Lordship. There is a thin line between quasi-judicial authorities and tribunals, Lordship. Quasi-judicial authorities are, of course, bound to act by the statute, but the tribunals go one step further. It is between the actual courts and the other authorities.
Right.
So
This
there
is
is
only an adjudicating body.
Yes. So therefore, that is the reason why this Guwahati High Court Superintendence of Tribunals Act has enlisted some of the tribunals, as your Lordship has pointed out. Because
there is more tribunals required to be, even if it is not there.
Yes.
227 power would extend even to foreigners tribunals.
Yes. Yes.
It's not there.
No, it is extended as per this schedule.
Schedule it is there.
It is extended.
There may be other tribunals also,
Yes.
which may have come up. But if we can exercise our power of superintendence, that tribunal, that system is there. But this will
System
not
should
apply.
be there like a
This will
court.
not, 227 power will not apply to CAT.
Yes.
Because that is under Article 323A tribunal.
Yes.
So to that,
Yes.
this power does not exist.
So because of this has been given.
But there is a clear-cut decision now.
Yes.
Okay.
My Lordship, I have submitted one more judgment. This judgment, though this is not a Supreme Court judgment, but this is of the High Court of the Chhattisgarh
Of which year?
of 2019. The order was delivered in 5/9/2024.
Was this case taken into consideration? Namit Sharma, no.
Against the order of the State Commissioner, the High Court under 227, the order of the State Information
You
Commissioner.
come up in 226, we will finish it off, no problem. But I can't exercise a jurisdiction which not there. Okay. Anything more? We'll have to dismiss your petition. Because there is a...
In that case, Lordship, I may be allowed to withdraw the...
You withdraw?
Withdraw the petition with the liberty to file...
Tomorrow you bring it. Tomorrow you bring it. I'll copy paste the order tomorrow for you. No problem.
My lord, can I file an IE to convert this petition?
Conversion will not be possible. Likhiye. Mr. T. Sunil, Learned Counsel for the petitioner. In response to the query made by the court as to whether the present proceedings would be maintainable under Article 226 of the Constitution of India, had made his submissions in the matter. Also, Ms. Tangan, Learned Counsel, appearing for the respondent, has on the issue referred to the decision of the Honorable Supreme Court in Namit Sharma versus Union of India, reported in 2013 1 SSC 745, wherein the Supreme Court in paragraph 77 of its said decision had held that the adjudicatory functions performed by the information commissions are of serious nature. An order passed by the commission is final and binding and can only be questioned before the High Court or the Supreme Court in exercise of the court's jurisdiction under Article 226 and or Article 32 of the Constitution, respectively, in relation to a State Information Commission and the Central Information Commission. Also, the decision of the Honorable Supreme Court in Namit Sharma Supra lays to rest the fact that the jurisdiction required to be exercised by this court against a challenge to an order of the State Information Commission would be that available under Article 226 of the Constitution of India. Also, in view of the said position, Mr. Sunil, Mr. Learned Counsel for the petitioner, submits that he be permitted to withdraw the present writ petition with liberty to file it by invoking the correct provision of law. Full stop. Prayer is not objected to by the Learned Counsel for the respondent. In view of the above position, the Learned Counsel for the petitioner is permitted. They are permitted to withdraw the writ petition with liberty as prayed for. Full stop. Writ petition stands dismissed on withdrawal. Interim orders, if any, passed stands vacated.
Okay.
Thank you. Miss Ete, there is that order. You will have to redo that because you see the period of his suspension from 1/6/11/93 to 17/11/2019 by the appellate authority has now been regularized for pension and pensionary benefits. So you will have to give him all the increments for that period on paper. Paper increments you will, but you have not given him. You come to page 17 of your affidavit.
Yes. Fifth
Yeah.
commission and sixth commission
No,
has
no.
only been
See,
implemented.
1/10/2092, fourth pay commission. You have got it? His pay was 1,000. Basic pay.
No, sir.
Then all of a sudden in 93, 1/10/93 comes to 920. I don't know. There is no reason assigned. Now he is on suspension from 6/11 to 17/11/2019.
19.
Right? Fifth
Yes.
pay commission 1196.
Yes.
Now you see his pay has been fixed at 2890.
Mm.
That whether you have taken the increments or not, that is not reflected.
Not shown. Mm.
Then you come to the increase in pay, it comes to 3050. He is again back to the initial stage. That cannot be because he is an employee working from at least from 82. So 3050, he is placed at 3050. It cannot be. Then you implement the 6 CPC, right?
6 pay.
Now you see here. 6 CPC 5,200 to 2,000 plus 2,000.
Mm.
Now you come to next page. His basic pay has been treated as 6060. Right, ma'am?
Yes.
2,000 grade pay,
Mm.
8060. Right?
Yes.
Now, after 10 years, 7 CPC comes. Right?
Mm.
So
Got
now
it.
you see 7 CPC, his basic pay has been taken as 6060 plus 2,000, 8,000, and he has been fixed at 21,700.
Yes.
So for 10 years, he remained in the same without increment.
Yes.
So that increment you will have to give. You redo this. Ask your authorities to redo this. I'll pass a number. Place it before us. We will then pass appropriate final orders. Man was insane. You yourself put him back now. Why don't you give him the full benefits, whatever is entitled? And I'm protecting you. I'm not asking you to give the areas. For that, let them go up on appeal, no problem. But I'm not giving them the areas.
Lots of me give direction, they will do it.
But I'm not disposing of. I'm keeping it. You get it done and give it to me.
Lots of,
Place it before disco.
lots of,
Who's up?
lots of, it will take some time.
Ah,
Very quick thing.
no rush. But Miss it's better than they coming back and filing a contempt and that line, let us do it in this manner, get some relief.
Yes.
Heard Mr. H.K. Das, Learned Counsel for the petition, and Ms. G. Tech, Learned Counsel for the state respondents. Also, the petitioner who was removed from his services he was removed or dismissed.
Lordship, remove.
Who was dismissed from his services, came to be reinstated in his, who was imposed with the penalty of dismissal, came to be reinstated in dismissal by the disciplinary authority by an order dated 10/5/1994, came to be reinstated in his service by the appellate authority by order dated 11/11/2019. So the appellate authority, while reinstating the appellant, while the said order had passed the following directions. Page 70, writ petition A to A. Also, the perusal of the said directions would go to reveal that the suspension period, also period of suspension undergone by the petitioner, as well as the period during which he was out of service on account of imposition of the penalty of dismissal upon him, has now been directed to be regularized as on duty. However, for the period, he was directed not to be not entitled to any pay. So, the disciplinary of the appellate authority further directed that the said period would be reckonable for pension, for calculation of his pensionary benefits. So, the respondents in their affidavit, the respondent number 5 in his affidavit has brought on record order dated 24/11/2020 fixing the pay of the petitioner with effect from 1/10/1982 onwards, that is, fixing the pay of the petitioner under the regime of the 3rd Central Pay Commission till the 7th Pay Commission. Also, a perusal of the pay fixation so made in respect of the petitioner, while the said order dated 24/11/2020 goes to reveal that the petitioner's increment with effect from 1/10/1993 has not been reckoned and or added to his basic pay. Also, accordingly, the basic pay of the petitioner stagnated at the stage when he had last discharged his duties. Also, accordingly, the period of his suspension now being directed to be reckoned for calculation of his pension and pensionary benefits, the petitioner would be entitled to have his increments during the period of suspension and also during the period he was required to remain out of service on account of imposition of the penalty of dismissal be calculated and his pay notionally fixed till the date of his superannuation. Also, the Learned Counsel for the petitioner has further submitted that the petitioner has not been also granted the benefits of ACP/MACP as would have been applicable in his case. Also, accordingly, the respondent authorities are directed to recalculate the pay fixation, recompute the pay of the petitioner for the period with effect from 1/10/1993 till the date of his superannuation, and by including the increments available to him during the period of when he had remained under suspension and or had remained out of duty on account of imposition of penalty of dismissal, refix his pay. Also, the refixation order, the process for refixation of the pay in terms of the directions passed herein above be initiated and concluded within a period of
3 months.
3 months from the date of receipt of a certified.
For 2 months, Your Lordship, already petitioner is retired on 2022.
Mr. I am cutting down your time. I can dispose of this. You will have to come back to me again with a contempt. Why? 3 months. Full stop. On the next returnable day, the fresh order now required to be passed by the authorities, refixing the pay of the petitioner with effect from 1/10/1993 and also including therein the increments due as well as the benefits under ACP/MACP scheme shall be placed before this court. So, registered to list this matter again on today's 18.
18 Lordship. Lordship,
On
after
20th.
brief break. After brief
28
break.
March, Your Lordship.
No. 1, 2, 3. On
20th.
24/3/2025.
Lordship.
I'm giving you enough time.
Obliged.
My lord, I heard it on the last occasion, my lord.
What was it?
376 matter, my lord, they were living together, my lord. The deposition has also come now.
Mm-hmm.
There is not a single, even a whisper of any physical assault. Under such circumstances, how can the trial in respect of 376 go on?
Who is for the victim?
Me, my lord.
What do you say?
My lord,
You're not keeping well over.
no, my lord, I'm good. My lord, about my lord, deposition, my lord, I humbly believe that, my lord, while exercising jurisdictional 482, my lord, will
I'm
not
not
look,
giving.
no, will not look into that, my lord. I humbly believe in the past regulars, my lord, to apply mine over those deposition with the trial court, my lord. Only in appellate, during the appeal, my lord will look at that, my lord. Now, if that is so, my lord will pass the appropriate order based on the matter collected by the investigation authority, my lord. Now, I will invite the kind attention of my lord to hear the deposition of the accused itself, my lord. 169 is still.
We'll have to hear this. 2019. That decision, Ms. Jenny, what was
Yes,
that
I
decision?
provided 2019
19, huh?
Both of them.
Both,
How
two
can you-
decisions.
by-
sir.
Yes, by the own admission, my lord. She got into a relationship with me, now rape, my lord. What is this?
No, my lord, that way, my lord, I try to.
No. We'll hear it. We'll hear it. This is not something.
I am relying on her documents, her FIR and her statement. What does he say? I sweet talked him into, that's all. The Supreme Court has said you made a conscious decision, even with the sweet talk.
Yes, my lord, that is not dispute. I mean, only there's a thin line, my lord, in the while interpreting
That
the
two decisions of the Supreme Court.
Yes.
my lord. No, that my lord, kind of those speak, my lord. Those who has the
Promise of marriage, how
Yes.
everything has been clearly stated.
yes, my lord. Those
At best, breach of promise to marry. nothing.
We'll have it after vacations. When? Tell, give me a date. Both of you. I made a mistake. I should have kept it yesterday. I could have. Heard the learned counsel for the parties admit the criminal petition. Also, raised it to list this matter again on, give me a date after the vacations, not the first week, thereafter.
Any date, my lord.
After that, you give me a date.
after vacation, my lord.
Whenever it's, give me a date.
What if stage event over 24? Tenth?
10/1/2025, 10/1/2025 for hearing.
Problem.
None appears for the petition on call. For the ends of justice, Mr. G. Taru, Learned Additional Public Prosecutor is present. For the ends of justice, registered to list this matters again after 6 weeks on a date to be fixed by. CD has come.
Yes, Your Lordship.
What is that?
Your Lordship, the statement of the girl has been taken, which is corroborating in the FIR, Your Lordship. Also, the medical report, Your Lordship, shows there are
Materials.
materials of, yes, Your Lordship, of rape, Your Lordship.
When were you arrested?
I was arrested on 10/11/2024.
And what is the minimum period? 90 days.
Yes, 90 days. Today is 30 days, sir.
Some more time. Is this custodial required? Any?
Your Lordship, only two of them was there. There was another person, Your Lordship, who has seen them in the jungle, Your Lordship. He has also given his statement. So there is no status, no comments as to by the IO if his custodial integration is required or not.
The case diary has been produced. So it is seen that the investigation has advanced to us, has advanced. However, the note of the IO with regard to the conclusions reached in the Malay. Heard, Mr.
Pakar Bagang, yes.
Just show me.
Yes, Your Lordship. I deeply-
164 has been recorded.
Yes, yes.
No, not 164. It has not been recorded.
As per my knowledge, you said 164 is already been recorded.
Heard the Lanark Council for the petition and also heard Ms. T. Ginny, Lanark Council for the respondents. Full stop.
The CD does not reflect, Your Lordship, 164.
So Ms. Ginny shall receive instructions as to whether it would be the new section, it would be
Pardon, Your Lordship.
164, the earlier one. Now it
Yes.
is
I'll have
BNSS.
to look into it, Your Lordship. $164. 183, Your Lordship.
Whether a statement under 183 of the victim has been so recorded. Full stop. Registry to list this matter again on 23/12/2024. CD produced is returned and an updated CD be produced on the next returnable date.
Deeply.
Madam, the medical evidence is also against you. Your own medical evidence is against you. Your medical examination establishes that.
Bless.
And also ask him by when he can file the charge sheet. Because the materials, all he has got is only to draw a conclusion and file a charge sheet. Yes, Mr. Singh.
In this case also, Lordship, case diary was called for. Earlier bail application was rejected by the learned judicial magistrate on the ground that the investigation is initial stage. So he has been under custody for.
Yes.
Yes, we have received the CD, Your Lordship.
What is that?
The CD reflects, Your Lordship will see that some weapons, armed weapons were
Where
stolen from the FIR, Your Lordship.
Any recovery?
Yes, we have recovered the pistol as well as the live rounds, Your Lordship. Subsequently, the correction was made in the FIR, Your Lordship. There were only, the stolen item were only 19 mm pistol as well as 11 rounds of live bullets, Your Lordship. The other rest of them were recovered from the custody of the police itself, Your Lordship. Now, during the investigation, Your Lordship, two of the IRBN they confessed to their part plate for stealing the pistol, Your Lordship, as well as the round. Subsequently, they have sold it to the present applicant, Your Lordship, along with another person, Your Lordship, and the same was recovered from the pedophile of the applicant. Now, this case does not stop here, Your Lordship. Subsequently, during the interrogation, Your Lordship, it has also come to the knowledge of the IO that firstly, that he is also involved in drug trafficking, Your Lordship.
This man.
Yes. Secondly, his address is not properly known. He's shown to be from Assam, but then it seems that he's being routed to Bangladesh, Your Lordship. Also, the fact that such there is also a presumption being made that such arms are also being supplied to the across the country, Your Lordship. Also, Your Lordship, there is also an
We are rejecting
apprehension.
it.
Lordship,
We are rejecting it. It's mine. I'm not satisfied what to do. You come back.
So far as the
That will come in the charge sheet. Don't worry. All this material will come in the charge sheet. So they heard Mr. AKC Planning Council for the petitioner. Also heard Ms. So-and-so. For additional public prosecutor appearing for the state respondents. So the present application has been filed, praying for enlarging the accused Nur Jamal Haq on bail in connection with Sejosa Police Station case number 10/2024 under section 306 of the BNS 2023, read with section 29 of the Arms Act, read with section 3 of the PDPP Act. Also, the case diary of the above noted police case has been produced by the learned additional PP and the same has been perused by this court. On perusal of the case diary, it is seen that the involvement of the petitioner is also found in connection with other offences.
Yes.
And the same is at a nascent stage of investigation. Also, accordingly, the learned PP submits that the release of the petitioner herein would scuttle the process of investigation, and the evidences required evidences of the case as well as witnesses may be not available for being produced during the trial. Full stop. The revelations made in the CD case diary as well as the nascent stage of the investigation, having come to the notice of this court, this court is of the considered view that the applicant here, petitioner, the accused herein is not entitled to be enlarged on bail at this stage. Accordingly, the bail application number so-and-so stands dismissed. None appears for the party on call. Registry to list this matter again.
May I, Your Honor?
Oh, you're there. Yes.
Your Honor, I'm appearing on behalf of NCAGO, leading counsel for the respondent. So I've received the petition recently, sir, Your Honor. So I've received the petition recently.
You're for the respondent.
Yes.
Where is the petitioner?
No, I have received the petition recently from the
No, where is the petitioner?
So I have no idea, Your Honor.
None appears for the petitioner on call.
Some more time.
Mr.
M. Tama.
M. Tama, learned counsel, appears for the respond number. You're for respond number?
Sole respondent.
Sole respondent. Yes, for the sole respondent. Full stop. For the ends of justice, you have to file your affidavit?
No, I have to file.
Mr. Tama submits that he be granted 4 weeks time to file his affidavit in the matter. Prayer accepted. Registry to list this matter again after 4 weeks. That's what none appears for the petition litigation, no? 30? 20. Yes. Ini picture maile ako. Kami itu loyo namu pa ito.
Lordship, this is I'm for the prisoner. This case is for the quashing of this one share case which is being pending at CGM 0.
Any private respondent here? The office note dated, peruse the office note dated 26/11/2024, which reveals that the trial court records have been received. Also, accordingly, registry is directed to list this matter after the ensuing vacations for admissions till the returnable date the interim directions passed earlier shall continue.
That's it.
Please, Lordship. Lordship, this is a joint petition for quashing of
Quashing?
case. Yes, quashing, Lordship. For quashing of Bandardua case number 48 of 2023 under section 380 IPC and the corresponding GR case number 933 public 2023 pending before the learned JMFC UPI person. Lordship, on 13/11/2023, a written FIR was filed at Bandardua police station by the petitioner number 1.
Where is your settlement deed?
Annexure 3 page 54, Lordship. Annexure 3 page 54. 54, Lordship.
57.
No, how come you knew that these are the people? You have not disclosed their names in the FIR? How come the settlement has come across?
Lordship, charges had already been filed. And
Filed, I know
yes.
that. So you don't know.
The accused were arrested.
If this is the formula, then there is no requirement of any criminal proceeding now. Criminal procedure. No courts are required. Everybody will after 1 month, 2 months will come and file a deed of settlement. Finished. Stolen materials have been recovered from one of the accused.
Yes.
Then not a fit case for. Sorry.
Lordship, the accused has also compensated, paid the compensation to the.
That is the reason,
Yes,
but that will not take away the criminal liability. That is what I wanted to know. That will not take away the criminal liability. Criminal liability will say.
In fact, Your Honor, my lord, the informant, he himself has appeared before the.
You go let the informant do whatever he wants before the tribunal, before the trial court. We are not going to come in.
Yes, Annexure 4, Lordship. Page 56, Lordship. Here the mayor. 56, Lordship. Annexure 4. Informant present here submits that he does not wish to pursue the matter further considering the plea made by accused persons to him. So he before the court also.
That is not the way. That is not the way.
Before the court.
And
also,
that is not even required because it's a criminal case. Your recovery has been made by you. Other evidences are there. They will proceed. Yes, Mr.
Yes,
Should be.
Yes, Section 27A disclosure evidence statement is also there.
There. And that recovered from the accused only.
Yes.
Yes, Lordship, but since the matter has been amicably settled,
no,
there is no.
We will not accept that. It's my power. I should be satisfied. I'm not satisfied.
Yes, that is there, Lordship. But since the accused and the.
Want to continue arguing or want to adjourn the matter?
No, Lordship.
Argue.
Yes.
You want to argue?
Yes.
Then I'll dismiss. Sorry, I've told you. No, okay, start.
Lordship, then let the matter may be fixed. After some.
Dismissed.
No.
Adjourn. On the prayer of the Learning Council for the petitioner, raised it to list this matters after 6 weeks. Oh no, there is an interim order. There is an interim here.
Yes.
Raised it to list this matter again on 8/1/2025.
Obliged.
Ma'am, item number 25 is an application for condonation of delay.
Objections filed?
Ma'am, in terms of order dated 10/9/2024, an endeavor was made to serve notice upon the respondent. Madam. Since she was neither there in the house nor in the village, madam, therefore, the notice was served upon the respondent's mother on 21/11/2024 in presence of one independent witness, and to such effect, I have filed an affidavit.
That we cannot take. Whether she is staying with her mother, whether she is there. This was done on 21/11 itself. No representation.
And to such a.
Why did you take the fresh address of the lady?
Well, she is currently in Tawang district.
So you take the current address, issue a notice. You don't know where your wife is. Divorce.
Divorce.
We are not accepting this. And she is appearing in that execution petition.
Yes.
Then why was it not served on her then on the next day?
She is not appearing, her counsel is appearing.
You can make a endeavor through the council, get her address. Then please do that. I'll adjourn it. When is the next date fixed?
7th of January.
7th. We'll fix it thereafter. You get her address, give it to us on the next date. We will issue notice on that fresh address, new address. On the prayer of the Learned Council for the petitioner, registered to list this matters again on 10/1/2025. You get the address, inform us, we will permit you to take steps.
Lordship, since last 3 months, I'm nowhere. I'm sitting at home.
Why?
But if kindly come to page number 25. Verify is the transfer order. I am at serial number 9. As APORE, DRDO, COME, Pasar. That is on.
I heard this matter.
Yes, 21.
Have you taken the steps?
Yes.
Anybody appearing for your appearing? Have you filed your response?
Today I have filed my Wakalatnama matter. I will be filing my.
Why are you sitting at home?
Because there is no order. Where should I go? Because I am transferred. I have
Okay,
joined already.
show me the orders of transfer.
Kindly come to page number 25.
First one.
Yes, 25. This is the transfer order of February 2024. I am transferred at serial number 9 as APORE DRDA COME from COME to Pasar.
You are at serial number
9. Vice
Only
serial,
come in.
vice serial number 10
APORE.
from COME.
What is this RE rural extension?
Yes, rural extension. Rural engineering.
You are tried from Yomi
to Basar. Vice serial number 10.
Sai-Kotin, Basar to Shemi. Okay.
Yes.
Then
This order is of February 2024. Then kindly come to page number 27. I have been released in the month of June. Page number 27. I am released. Page number 29 is my joining report as APORE on 11 June. And page number 30 is the order of the Deputy Commissioner, come CEO. I have been posted as APORE in Basar district, page number 30.
Page 30.
Yes.
This is the consequential order.
Yes. Then what happened, Lordship?
Hmm.
Page number.
Just a moment. Posting consequential order.
Page number 48. This is the note of an MLA, concerned MLA of that district. That, as mentioned above in the subject, I am forwarding herewith an application received from the private respondent. He is seeking for the look after charge of APORE. He is already posted there in Basar. He is already doing his duties as EORE. Now he is seeking for temporary charge of APORE, wherein I have already joined and I have been given the charge. What happened, Lordship, thereafter? An order is passed. Page number 52. See the date, Lordship, 26 July. More than after 1 month, I have been posted. I've been allowed to take about the charge. Then on 26 July, another order passed. This is by the diagram.
Where?
52. I am directed to convey the approval of the government for allowing the respondent or private respondent, CD block to temporarily hold the charge of APORE under buzzer such and such. Now, this causes some kind of confusion. Thereafter, what happened, Lordship? Some clarification has been asked by the Deputy Commissioner. That is on
Where is your original order of transfer page?
page 25. It is the first order. I have been posted as APORE. Now, what happened?
What is your original post?
I am TA, Technical Assistant RE.
Technical Assistant
RE.
RE. And what is the original post of?
He is EORE,
Huh?
Extension Officer.
Extension Officer.
The difference between us is only the pay scale.
So where is that order, subsequent order?
After
How could you have been posted as AOAP? APORE, how could you have been posted as AP?
because lots of the next higher post
I know
is
that.
APORE.
I know that. You have been said to be holding the post of APORE to APORE you went.
Yes.
How can that be? That is not your substantive post.
Then in that case, lots of kindly come to the notification. Page number 35. This is the notification. It initiates from page number 33.
What is this?
This is the kindly come to the order.
This is the absorption of DRDA employees.
Yes, to RD.
Huh.
I am at serial number 64 at page number 35. I have been
64,
shown as
TMB.
APORE. Yes.
You have been absorbed as APORE.
Yes. Page number, serial number 64, page number 35. As per this notification, I am APORE.
And the private respondent?
He is extension officer.
Where is this? Where are the materials?
Materials, Lordship, kindly come to. Page number 52, it clearly says, page number 52, I am directed to convey the approval of government for allowing Sri such and such EORE
Okay.
as look after charge.
So now what happened then? What is the final order passed?
Final order, Lordship, that is 8 October, page number 63.
When did you file this writ petition?
October 2026.
Why from July onwards, if he is holding the charge, why were you not?
From June.
No, from July when he was given this order.
Yes.
Why were you not? Why did you not
Lordship, I have submitted a representation before the secretary. That is here, annexure. Nothing has been done. Thereafter, some clarification were called.
Then 60, page impugned order 63.
53. Lordship, kindly come to page number 54. It will clarify. Page number 54. This is the clarification sought by the PD.
Who is appearing? What is this?
Whether he is APORE.
Forget if he is APORE or not. You have transferred him as APORE.
Yes, ma'am.
You have taken him there. And you keep him there and you bring somebody else to look after the charge. Where will he go? Who is functioning now?
Now the private respondent.
Private respondent.
My lord, may please come to my lord.
Then what about this order? Governor's order, while absorption as so and so. Please to order absorption, so and so in there. Now they have been absorbed as APORE.
No, my lord, that is subject to correction, my lord.
Subject to correction, where you have not correct. Have you corrected?
My lord, we will be correcting because, my lord.
Where? You correct and
Yes.
then take formal steps.
My lord, may please see serial number 64, my lord, page 35.
I've seen it.
APURE, his pay scale is 9,300. It
Yes,
has
that is to be
mistake.
corrected.
There is a clerical mistake. Malad.
Maybe that is to be corrected.
Yes, Malad, because his substantial post is TAIWP. Malad.
And moreover, Lordship, my grade pay is also shown.
Mr. You have projected, come to the order of transfer.
Yes, Malad.
25.
Come to the order of transfer. Page 25.
Yes, Malad.
Come.
That is there, Malad.
That, why? If it is there, it is there.
Malad, we have made a clarification, Malad. The project director has sought clarification and
You
the
forget the clarification. You have considered him as APURE, taken him there.
Malad.
Now, if you don't want him, transfer him somewhere else.
Somewhere.
But how can you, without modifying your this order at page 25, bring somebody else and put him there? His pay is now being held up. Your pay you are not getting. Pay you are getting.
1 month I have been paid for initial month.
After that, no.
No.
Malad,
So this cannot be.
our case is this one, page 56, Malad. This is our case.
Any affidavit file?
No, Malad. We are about to.
With reference to so and so, so and so, so and so, so and so.
Kindly come to second paragraph.
Upon reviewing your appears that you note down two documents related to designation, however, there is no record evidently indicated in the government was ever committed on. Therefore, unless there is a relevant order of communication, it should be considered as TA. Who is he?
He is TA.
Oh, no, who is he? Who is he?
Director, same person who has transferred me.
Who is he? This is an order by the government.
Yes, Malad.
How can the director?
This is a clarification, Malad.
Fine.
Yes.
This order modified, finished. Without modification, how can the director do this?
Because he
I'm
cannot.
sorry, you don't have the power. Director does not have the power. Because this order, I say it's wrong. No issue on that. Modify it. Then take whatever steps. We are staying this for the time being.
Malad,
Mr. Sakya, you already have a post there in Basar itself. You continue in that. Who's up? No, where you just, Mr. Sakya, tell me.
By the director, on behalf of the
Director, I accept that his order, he is not an APO. But the government had made him an APO in page 33. I know this is wrong. Can I clarify, modify this order, then take whatever steps you are. Now, where will he be posted now? Where is he getting his salary?
His substantial post is,
Wherever he is substantial.
that post is vacant, madam.
Where?
It is vacant, madam.
Who has posted him? Can he go and sit in a post on his own? Somebody has posted him. They are only concerned about you, not about him.
Kindly see the transfer order, madam, from COP to madam. Initially, madam.
Come. Dada Basar. No. We'll go by this order.
Because of some mistakes by the department, can he?
Where is that reflected here in the order? Is there a consequential order passed saying that your posting as APOE is null and void because you are not that, you are posted as so and so? Is there any order? No, but it's not there.
But, madam.
Malad, the third paragraph.
Which one?
Page 56, third paragraph.
Page 56, third paragraph.
Therefore, unless there is relevant record or communication indicating such a
Now again, see,
should be considered.
this is, you come to the fourth paragraph.
Yes.
Karan Basar maybe so and so should be considered as so and so. How can he say this? Because he's not the one who is giving the approval. It's by the government. The director is not the government.
Transfer order.
You file your affidavit. Post up. Considering, post up. Heard Mr. So and so, learned counsel for the petitioner also heard. Baki sabka we are only staying in. We are staying it. You file your application. Let them file their affidavit. I am not restraining the government from taking any consequential action that is required. But on the face of it, this order cannot be sustained. If you want me, I'll dispose it off. No problem. I'll give the liberty to the government to take consequential steps. Or we'll state, you file your affidavits. We'll consider. I'll put it the matter in second week of January. Heard so and so. The petitioner in the present proceedings have presented a challenge to an order dated so and so. Order dated 8/10/2024, by which the respondent number Respondent number 5 has been allowed to hold the charge of APO RE, Lepar Dapa District, Basar. Same post. Or it's something else.
Same.
Okay. Also, it is the contention of the petitioner that he was void an order dated 22/2/2024 issued by the government in the government of Arunachal Pradesh in the Department of Rural Development, Itanagar, absorbed in the Rural Development Department as an APO RE. So thereafter, the petitioner was transferred by order dated 21/2/2024 from the DRDA Shi Yomi to DRDA Basar. Also, the post held by the petitioner at Shi Yomi was so filled up by one Sai Kotin APO RE. Also, the petitioner joined his duties on being released from his joined his transfer place of posting wide on 11/6/2024 and has been continuing in his services thereafter. It is submitted by the petitioner that I'll dispose it of, but I'll provide that this thing government can do.
Instead of this, we may be allowed to file affidavit.
Okay, fine. It is submitted by the learned counsel for the petitioner that the private respondent herein, who is an EO RE, being desirous of holding the charge of the post of APO RE, current which was held by post of so and so held by the petitioner, had brought pressure upon the departmental authorities, and the same had led to the issuance of the order dated 8/10/2024. The learned counsel for the petitioner has further submitted that while the respondent has been allowed, respondent number 5 has been allowed to hold the charge of the post of APO RE, Lepardapa District, Basar, which he was so holding on his transfer thereto by the order dated 21/2/2024, no order came to be passed with regard to the posting of the petitioner, and accordingly, with effect from 8/10/2024, he is without a post and the salaries are not being released to him with effect from July 2024.
No, from after October.
From October 2024. Full stop. Per contra, Mr. Pincha, learned counsel, appearing for the state respondents, has submitted. Mr. Pincha and Mr. R. Soikia, learned counsel, appearing for the respondents, have submitted that the petitioner is an incumbent in the post of, what is this TA? Technical assistant.
Technical assistant.
Technical IWMP, and
DP,
it was
IWDP.
DP, and it was only on account of an clerical error that the petitioner was shown to have been absorbed against the post of APO RE wide the order dated 22/2/2024. Also, it is submitted that the same was being rectified. Also, accordingly, the learned counsel for the respondents have submitted that the petitioner has got no locus to institute the present proceedings, inasmuch as his substantive post has not been filled up by the respondent number 5 herein. Full stop. It is further submitted that the petitioner is not entitled to hold even the charge of the post of APO RE. Full stop. The said contentions have received the consideration of this court, and this court has also perused the material available on record. Full stop. As noticed herein above, the petitioner was absorbed as a APO RE wide the order dated 22/2/2024.
Kindly mention the scale also, in the scale of. It's important, madam.
Okay, fine. That then he will say that is a clerical error that is to be. Why should I go into all this? I'm not foreclosing your thing. I'll put it. He लिखिए Rajan. So and so. Thereafter, by the order dated 21/2/2024, the petitioner the petitioner was designated as a APORE and he was transferred in the same capacity from DRDA Shi Yomi to DRDA Basar. The petitioner, it seems, has also joined against the post of APORE in Basar and he was permitted by the authorities to continue against the said post till the date of issuance of the order dated 8/10/2024. Full stop. The learned counsels for the respondents have also referred to a communication dated 29/2024 issued by the Director of Rural Development Department, wherein he has contended that there is an inadvertent error in designating the petitioner herein as APORE in the said order dated 22/2/2024. Accordingly, it was directed that until the said order dated 22/4/2024 in concerning the petitioner is corrected, he should be considered as a TA bracketed IWDP. And the respondent number 5 be permitted to hold the charge of APORE. The said communication dated 29/2024 goes to reveal that the designation of the post against which the petitioner was allowed to hold charge and which is said to be erroneous has not been corrected till the date of issuance of the order dated 29/2024. It is submitted at the bar that the said order till date has not been corrected. If the above is the position, the petitioner has to be deemed to be an incumbent in the post of APORE, and accordingly, when a regular incumbent in the post is available in the station, the said post now cannot be permitted to be held on charge by a person from a subordinate cadre. So, in view of the above, this court being satisfied that the order dated 8/10/2024 has been erroneously passed, directs that the same hereby stays the same till the returnable date. The petitioner shall be allowed to continue against the post of APORE and his pay and allowances be also regularized in the manner required with effect from 8/10/2024. So the above directions are subject to, would be further considered on the returnable date after the respondents have filed their respective respective affidavits. Also,
He was allowed to join as a APORE, but in the scale
On
of
his
matter-
own page.
That has been mentioned by the order itself.
you clarify that. Even now you clarify, bring it to the notice, we will vacate the order. Simple thing you don't do, you complicate matters.
May I please, Your Lordship? Your Lordship, I'm appearing for respondent number 3, Your Lordship. We'll be filing our affidavit, Your Lordship.
Respondent number 3. Madam, respondent number 3 is who?
DC, Your Lordship.
DC, okay.
That's a small correction. For month of October, I have been paid.
Till month of October.
No.
With effect from?
For the month of October, I have been paid.
Okay.
November,
With
I get
effect from November 2024. Mr. Soikia, Mr. Pinja, correct that. Bring it to our notice. We will vacate
Yes,
it.
Lordship.
But till you don't do it,
I must-
how can I?
I must-
A regular incumbent cannot be, because there is no material. And your director is not the authority, unfortunately. It's the government who has to.
He was allowed to hold a charge on his own pay scale.
You have not allowed to hold the charge. You have posted him as APOE. That is the mistake you made. I considered this issue earlier also once.
No, Lordship, since the
Respondent
steps,
was.
yes, steps are not taken.
Okay. Mr.
Highly-
Soikia, get the things done, come back. We'll finish it up. No, dispose them. Okay,
returnable registry.
Oh, registry to list this matter again on 17/1/2025.
Hello, can you say, first week of April?
First week,
First week, Lordship, I am not here.
you're not here.
Yes. my
Then you
sister's
come
marriage
back
is
by
there.
10th.
Yes, Lordship, 12 to 15 any date.
No, no, 10th.
13 to, no, Lordship,
10th.
my sister's marriage is there.
Okay. So when are you coming back?
After 10.
After 10.
Yes.
So we are putting it on 15. 15.
Okay.
15.
Oblige. Oblige.
But this is only a temporary relief. Moment they correct their error, you are out.
I must say one thing, if they are going to correct the notification, entire notification will have to be correct.
Whatever it is, that
there
is
are
clear.
lots of
But
mistakes.
they correct that part.
And they can't do that.
And government does it. The government has the power.
No, no.
If it has
they
made
are
an
not
error,
going
it
to
can.
do. They are not.
Mr. Saxena, if it comes back to me, I will not even hear you. I'll vacate that.
That's why I'm saying, my lord, they are not going to do anything.
Proposition was he just.
They will just correct my, they will just correct my salary. That's all.
We'll get it. Let's see who is more powerful. None appears 40 parties on top. Registry. Oh, you're there. Yes, ma'am.
Lordship, petitioner in this case is demise, Your Lordship. So we were supposed to file an application for substitution, but we have tried to contact the offspring and the relative of the petitioner, but they are not responding, Your Lordship.
Who is appearing for the state?
Private.
Okay, you are against the conviction, setting aside of the conviction of the opposite party.
Yes.
You may have a case. She was the wife.
Yes, Your Lordship.
Who is there now in the family?
Her son and daughters are there, but
They
they are
will
not
not.
responding.
Then what is left here?
Yes, Your Lordship.
Withdraw it. So it has submitted by the Learned Council for the, Madam, your name?
D. Riba.
Riba, Learned Council for the petitioner that during the pendency of the present proceedings, the petitioner had expired and there is none left to step into her shoes for conducting the present appeal. Present petition, present revision petition. So accordingly, she prays that she be permitted to withdraw the present criminal revision petition. Accordingly, on prays that the present criminal revision be closed on account of the death of the petitioner hearing. Prayer accepted. The present criminal revision stands closed on the death of the petitioner hearing during the pendency of the present proceedings. Yeah.
This revision petition against the ex parte order passed by the village authority of the
Go before the civil court. Why are you before us in a revision? Now an appeal is provided for.
here I'm
Show me that it'll be maintainable. Because now then appeal is, any decision appeal is maintainable before this senior civil judge senior division. Then
recently in CRP number 11, this honorable court has interpreted
who is there for the private respondent? You are there.
number private.
I'm sorry, the court was not brought. Court was not brought to notice about the other one, the AP Code, Civil Code Act. That now takes care of the matter. It does not say 3 years. It can go in the first instance itself. 3 times it's not says.
Phase 4.
Page. And you come to the second amendment. Now this, if agreed to by the, that is also gone. Provided further that so and so is the case, maybe shall not so and so, so and so. Any party agreed by a decision of the village authority may appeal within 30 days so and so by whatever name so and so, so and so. Provided for an appeal writing out of the village authority, so and so shall lie before the Court of Civil Judge Junior Division, so and so, so and so, so and so, as per their taking territorial and pecuniary jurisdiction, so and so, so and so. No, an appeal is provided for. Why should we come in a revision petition?
Well, in this case, I am only question the jurisdiction.
Jurisdiction, take it up. It's a plea you can take up in an appeal. Withdraw this, go, we'll provide for. Yes, Mr. Counsel, what do you say? Oh, you're not the counsel. Who is there for the respondent?
They are not appearing.
They are not appealing. They know, they are confident. They are confident that this case would be dismissed. Mr. Modi, why waste time here? Withdraw this, go there.
Yes, madam. But would liberty.
Not with liberty. Mr. Pusab, the instant revision petition has been instituted, assailing an order oblique decision dated 6/5/2023, passed by the Tekang Bane Kabeng Kebang. Pusab, the said decision of the Kebang passed by the village authority is in terms of the provisions of the Arunachal Pradesh Civil Code. Civil Code Act 2021, bracketed as amended, is key issue. So and so is appealable before the competent civil court as provided therein. Also, in the above view of the matter, this court was of the consider the present revision petition would not be maintainable. Also, Mr. Modi, in view of the provisions of the said Act of 2021, bracketed as amended, submitted that he be permitted to withdraw the present revision petition with liberty to approach the appellate authority. Appellate authority in the matter. Post of prayer accepted. The revision petition stands dismissed on withdrawal with liberty as prayed for. Yes.
May I please, Your Lordship?
In
serial
automatically.
Yes, my Lordship. In serial number 22, my matter already adjourned. Regarding that, the opposite party take the time to file an affidavit in oppositions, 4 weeks already given, Your Honor. Regarding this matter, Your Honor, as per the record in order sheet.
Show me 22.
Yes, serial number 22.
You're for whom?
The petitioner, Your Honor.
You were not here.
Exactly right, not here.
Yes, what is it?
Yes, my lord. Regarding this matter, as per the official note sheet, it's clearly mentioned that on 4/11/2024, the learned council already received the copies and notice prior to the date only. And
you have furnished a copy.
Yes.
On 11/12/2024.
Yes.
Learned counsel for the petitioner has furnished the extra copy so and so for sole respondent. The receipt of the same is placed on record.
Yes, my lord.
So what do you want?
Apart from that, my lord, on last I dispose of in the second file, my lord, in the order dated 79/24 is clearly mentioned that the IA along with the main copy already served to the.
What do you want to do?
Yes, I wanted that, Your Honor. They took the 4 weeks time. It's too lengthy, Your Honor. If possible, short date maybe.
4
Because
weeks तूने कौन लिया?
already 4 weeks given, Your Honor.
बुनी उसको 4 weeks के बाद एक डेट दे दो. List this matter again on so and so. 4 weeks बोला ना? 4 सप्ताह के बाद एक डेट दे दो.
Specific.
Specific date. Okay. Done. Okay.
I'm the LAC, my lord. Much of that.
Itu bunik kau dia. Item number kiman? Tuman ni. Artikel le kau dia.
My plea, Lordship.
When were you in custody from?
3rd December.
3rd December.
Yes.
The other day. What is the offence?
The offense is allegation is below the punishment is below the 7 years, and the production was made on 4th December. In the production forwarding letter, it is clearly indicated that the entire statement has been recorded, and their offense material evidence has been already seized by the police, and police were paid political custody. So as per the foreign letter submitted by the IO, the detention of accused person is not at all required till that. And 16th of this month, we
Get your CD.
this is my lord, purely a family dispute. The fighting was made between the
You want a bill?
sister
You
wives.
want her me to release her today itself? Show me materials. I'll release.
Yes. Kindly, I may be allowed to read the FIR.
Forget the FIR. Show me that how you are not related to that offence.
Yes, this my lord, here offense is alleged in the FIR. Here, when the case was registered,
So here the allegation is that somebody, maybe you, tried to block the vehicle of the informant, and thereafter even chased the vehicle, snatched money purse, 14,000, physical assault to me along with my 1 month baby.
that is a FIR lodged by
Be
the
that as it
victim.
may, so I'll have to see the CD. What is the?
My lord, that is FIR lodged by
You
the
have a
victim.
video of that place at that point of time.
In this case, two FIR. This is another FIR.
There is
This-
another FIR.
Yes.
Okay, where is it?
Kindly, page number 29 is the FIR in this case.
Hmm.
And type out is 30, page number 30. FIR against Charu Ake.
Okay. There are 2 cases registered.
Yes. This first FIR.
Madam, get the FIR of both the cases.
Yes.
But so and so, so and so. The present bail application has been filed for regular bail in connection of the accused
Charu Ake.
Charu Aki in connection with Papu Hill Police Case, State Police Station Case number 98/2024 under Section 74/324 bracketed 4/118 bracketed Roman I /3 bracketed 5 of the BNS read with Section 27/25 bracketed 9 of the Arms Act. Issue notice. Ms. Hage shall on the next return date produce the case diary. So Ms. Hage shall also produce the case diary of this is 98.
Yes, in this case 98. 99 is another case.
Where is that FIR?
That is here, just
Page 29.
Yes.
That is 98.
The 98 in this my case. So 99 is a
99.
Yes, 99 is a counter FIR lodged by the victim.
Now you want in
98.
your FIR against you is at page 29,
98.
right?
Yes, this
Along with the case diary in Papu Hill PS case number 99/2024 under section 126 bracketed 2/304 bracketed 2/281/117 bracketed 2/3/5 or bracketed 5 BNS 2023 stated to have been so instituted basing on an FIR filed by the wife of the accused herein, right? Filed by your wife.
Yes, here two wives, sister wives, fighting between two wives.
Oh.
And in the meantime, the accused intervened in order to
So stay inside for a few days. You will be also in a
15 days the custody.
That is peaceful. You are in peace now. If you come out again, there will be a fight.
So, my lord, by
Fix
next
when, madam?
Monday,
Monday, 23.
23rd. Oblige.
Seems to be a matrimonial dispute.
Yes, Lordship. Between the two wives.
So you be there. Pray that you be there for, you ask us to make up prayer for 15 days, 20 days afterwards. You're peaceful. Yes. Is that?
My lord, this is a previous bail application, madam. Lordship, and affair is on page 17. Lord. It's a murder by a group of 5 persons or more, madam. The section 1032, Lordship, of BNS now. Lordship, page 17 is the affair.
What is your name? What is the accused name here?
Tabin Lamgu.
He is a named accused.
Yes.
Get your CD.
My lord, if Lordship, the present applicant, my accused person, is one of the bar members, my lord. On that day, Lordship will kindly see page 22, my lord. He was present for Lok Adalat, my lord. He was one of the members of the Lok Adalat. Therefore, but there was the alleged incident happened on 13, Lordship. Kindly see page 22. This is the notice issued by the district.
Where is that FIR?
FIR is page 17, man. In FIR itself, man, it says man, what happened. Yes, man, what happened? Just 1 minute only, man. In 2025, what happened? The father of the present applicant was attacked by this disease, man, and caused grievous injuries, man. Against him, and FIR was lost. A case trial was done, man. Now, when that accused person, man, has been killed by someone, man. Now, this complainant believes that it is a revenge killing, and all the members of this applicant, entire family, brothers and sons, have been made as an accused person.
Who is Quashing Lambu?
He's a teacher, man.
How is it related to you?
He is my uncle of the applicant. He's a block education officer. All the close relatives and sons of the applicant, the brothers of the applicant have been made as accused person. Pure suspicion, man. Believing that it might be a cause of.
Okay, let's see what material comes.
No, man, kindly appreciate, man, the applicant has to go for a surgery also. His leg was.
We are only asking. We'll get a scan copy on 23rd.
Yes, sir.
23rd. Case diary on 23rd. 23rd.
That's why I'm stressing, because I wanted interim, man. Kindly appreciate, man, the page 22. Just look page 22 and 23, Lordship.
See, the time he is not given. It says morning.
Yeah, forenoon, he has maintained.
No. Went to his agriculture farm at Badung, so and so on, 2 and so.
No, 10
morning.
No.
How can he is not? Farm normally people don't go at 10. They go early in the morning.
Time is given, Lordship.
Where?
Page 17, down below, Lordship. That's why he has been made.
Where?
Late Longyang Lordships.
Along with the vice copy of Tabing Lambu was spotted on the.
Yes, 10 a.m.
Good.
This is very far off place.
Now, show me. This is a notice at page 22 asking him to appear as one of the members.
Oh, yes, on 14.
Did he appear?
Yes, man. Now, next page, man. Can you see, page 23, man? The learner system said on 13, they were asked to present on 13 as a members, man. Can you see, man? The second.
So where did he appear? On 14, did he appear?
13, since 13, he is there, man. Can you see page next page?
How far is this place from?
This would be around 35 to 40 kilometers. And that also approach road. Thereafter, they have to go foot march.
Okay. We'll ask him to appear.
Yes, regarding him, Your Lordship, I will lead with your Lordship. I will get this case there, Your Lordship.
Mr. So-and-so, Learned Counsel for the petitioner, also heard Mr. E.A. Learned Counsel, Learned Additional Public Prosecutor. The present application has been so instituted, praying for bail pre-arrest bail in connection with the pre-arrest bail in connection with the accused applicant Tabi Langgu in connection with Chayang Tajo Police Station case number 6/2024 dated 15/12/2024. Also, a perusal of the FIR brought on record would go to show that it is being alleged in the said FIR that the incident occasioning therein had so occasion at around 10 a.m. of 13/12.
Yes.
So 13/12, that is again dicey.
13 to page 23 can be similar. That's why I was showing you a lot. Page 23 can be similar. The second, last paragraph. The said case will be placed for pre-hearing.
Who is Tabajamu?
This is we are showing one of the notice that was issued.
That notice is not issued by the you.
No, kindly see. This has been issued by Secretary Malardi. 13 December in premise of CGM Court SEPA at 10 a.m. in order to provide an opportunity to the
13.
parties to negotiate the case in
Okay,
advance.
we'll take
As you are
we'll take it.
before the board, Malad. So he's
Has
one of the
been
board members.
Stated to have been so occasion on 13/12/2024 at around 10 a.m. It is the stand of the learned counsel for the petitioner that on the said date, the accused applicant was as a board member of the National Lok Adalat of the district of the Chief Judicial Magistrate cum Civil Judge Senior Division was as a member of the board constituted by the District Legal Services Authority, participating in the pre-negotiation settlement proceedings in connection with the cases so directed to be taken up in the Lok Adalat on 14/12/2024. Accordingly, it is submitted that the applicant accused was not present at the place of occurrence at the time so indicated in the FIR filed by the informant therein. Accordingly, it is prayed that the petitioner be granted a bail, interim pre-arrest bail. I've heard the learned counsel for the parties and considered the materials available abroad. Prima facie, it having been brought on record that the petitioner on 13/12/2024 with effect from 10 a.m. was as a board member participating in the proceedings of the pre-proceedings of the National Lok Adalat, which was slated to be held on 14/12/2024, that is provided that in the event the petitioner is arrested in connection with Uparwala, Chayang Tajo Police Station case number 6/2024 under section so and so 482 under section
1032 238A.
You don't mention those in the
I'm sorry.
103 bracketed 2 238 bracketed A 61 bracketed 2 ऊपर में भी लिख देना. He shall be released on interim pre-arrest bail of rupees 30,000 with 2 local sureties to the satisfaction of the arresting authorities. Subject to the following conditions. The petitioner herein the accused applicant shall appear before the investigating officer on or before today is 18, no? On or before 24/12/2024 and have his statement recorded. Right? We can have it immediately on reopening then.
Okay.
24/12/2024 and have his statement recorded. बाकी जो normal conditions है लगा देना. Registered to Mr. Ete shall on the next day, on the returnable date, produce the case diary in connection with the above noted police.
Maybe scan copy or not.
A scan copy of the above noted CV case diary or a scanned copy of the case diary of the above noted police case. Registry to list this matter again on when? 3 or 7? 7? 7/1/2025.
Obliged.
Your Lordship correctly pointed out. I also saw Malad, the sections were not put Malad.
Obliged, Your Lordship.
Obliged.
May I please lawsuit? This is Miss case for restoration of writ petition of 488 of the 2024, which was dismissed for default on 13/12/2024 for non-appearance of the counsel for the petition.
Okay, we'll take it up on merit.
Yes.
What do you have to say?
My lord.
What do you have to say on the case?
Yes, my lord. My lord, on merit, my lord. And they have filed their affidavit.
Affidavit, yes.
Yes, my lord.
And they have, you have not even touched on it. You have not even filed a reply.
My lord, they have filed affidavit, my lord.
Show me, show
2
me,
days
show me
before,
the
my
file.
lord.
Huh?
My lord, this 2 or 3 days before.
No. (4/12).
Yes, ma'am.
And the dismissal is of 13/12.
But
These are tender matters. This can't be kept waiting.
my lord, I have received this copy, my lord, their affidavit on 8 May. My lord, my lord, it is served through the advocate clerk. He is furnishing the.
That your advocate clerk has not given to you, change him. But that cannot be a ground.
So not my advocate clerk,
There.
our filing assistant. My lord,
There is nothing here, Mr. We wanted to dismiss it on merits, but you were not here, so I did not proceed to dismiss it upon merit.
can you give me a chance, my lord? I
Well,
will, I will, my lord, convince your lordship, my lord.
You do, convince me now.
My lord, my lord,
You had taken 2 pleas. One,
yes, my
that because of the holidays, you could not procure.
lord.
Now they have said, now holidays or no, we have kept our offices open, and on that day also tenders were given.
My lord,
This last date was 15th.
15, my lord.
You filed this, then the tenders were settled
Yes, my lord.
on 24 or 25.
yes, ma'am.
And you filed the present writ petition only on 30th.
Yes.
My lord, there is representation before the secretary, my lord.
Be that as it may. The
On 16, my lord, on 16, my lord, I have filed this representation before the secretary, my lord. Page 20 of my.
and you also knew as to the parties who have been now given the tender, you have not brought them on record.
My lord, how could I know, my lord? I am not.
Because that
participating.
affidavit was filed. And they had there was an order also here somewhere.
Well, they came to know about the corrigendum NIT on 11/10/24, madam.
And see, you knew about the corrigendum in terms of your own statement
Yes, madam.
on 11/10 itself.
Yes, madam. And they never went to the office to purchase the documents,
No,
madam.
my lord, no, my lord. That is.
You are not
the case, my lord.
interested. You are not a person interested. You are just.
Extension of time that can be understood, but madam, they have not even
Mr. Lam,
purchased
come
it.
to page 4 of your affidavit of your writ petition.
Yes, my lord.
The said corrigendum, third line, the said corrigendum, page 4, said corrigendum was published on so and so, and the last date for submission of tender paper was mentioned as so and so, out of which 3 days were holiday, thereby deprived the so and so. Now, people are buying this in their record they have shown on 12th also, and they have submitted. What prevented you?
My lord, may I point out one thing, my lord. My lord, since my lord, in this case, record may be also necessary, my lord. But I'm sorry, kindly see the, my lord, that,
What is your ground for this
Sale register, man, page 64, kindly see, man. Page 64, man.
forget it. Now, what is your ground?
My ground is, my lord, is for the CPW manual, my lord. If the.
No. For restoration.
Oh, my lord, for the restoration, my lord.
Hmm.
My lord, on that day, my lord, on 12th, my lord, when, my lord, my lord, going through the cause list, my lord. I inadvertently, my lord,
Why it was,
going to,
this is only two quotes you have here. How can that be a ground?
my lord, no, my lord, it's was listed on 13, my lord.
13.
Yes, my lord.
13.
My lord, it will come up 12, my lord. Before one day, the cause list come to us, my lord. While going
I get
through
it. I get it 1 hour before.
yes, my lord. When going to the down there, I accidentally, my lord, yes, it went out from my side, my lord. But this case was listed on 13, my
Your
lord.
name was there. We waited. First round, I did nothing. Second round, and then seeing the
Actually,
matter, I
third
wanted
round.
to dispose of the writ petition.
My lord,
But I gave you because you were there. You might have something, so I kept it.
my lord, this is not deliberate intention, my
I
lord.
know
Had my learned friend has called me up, my lord, I would have, my lord. My learned friend even.
He also did not think that you are not here. He-
My lord, I'm not here, my lord. That's the, my lord.
Okay. Heard Mr. H. Lambu, Learned Counsel for the petitioner. Also heard Mr. B. Pincha, Learned Standing Counsel, Rural Development Department. The present interlocutory application has been filed, praying for recall of the order dated 1/11,
13.
order dated
13.
13/12/2024. Oh, 13/12/2024 passed in WPC number 488/2024, dismissing the same for non-prosecution. So the petitioner, Learned Counsel for the petitioner has submitted that he had inadvertently, while checking the cause list, missed the writ petition, although the same was listed
On 13/12.
item WPC number 488. No?
488, my lord.
Very clearly that. You give me a better ground.
My lord,
Something to likho. Why this?
my lord,
Something wrong. But you were not there. See, whatever it is.
my lord, honestly, that, my lord. Honestly, my lord.
As
That is the reason.
but inadvertently missed. So, perusal of the cause list for 13/12/2024 of this bench reveals that the said matter was listed and the name of the Learned Counsel for the petitioner were also reflected. Be that as it may, the petitioner having, the Learned Counsel for the petitioner having submitted that the case was missed out on account of was inadvertently missed out by him while checking the cause list, comma. The order dated so and so is recalled. 13/12/2024 is recalled. The writ petition is restored to the file. So, however, considering the nature of the dispute arising in the present proceedings, this court is of the considered view that the interim order dated 1/11/2024 will not be extended any further.
My lord,
Finished. You have all that already. The attended. What was the interim order? That if work order is not issued, work orders have been issued.
no, my lord, not issued.
Then you file an appeal against that. I'm not. Prima facie satisfied. I restored your writ petition.
My lord, kindly.
No.
Well, so that may be given, my lord. Let it be on 24, 25, 24, my lord.
Yeah, writ petition. In view of the order passed today in IAC number so and so, the present writ petition has been restored to the file. Registered to list the writ petition again on. You will have to file a reply also.
Yes, my lord.
File a reply.
January.
January only now.
My lord,
20/21/2025.
Yes, my lord.
For admissions.
my lord.
See, the private respondents are not before us. Neither you have made them parties. Now, secondly, you have missed the bus.
Yes, sir.
So those things have to be disputed. How can I ignore that?
No, kindly appreciate, my lord. My lord, so right now I have not get that development. My lord, I have filed RTA also. for
Fine, you
getting the
do
documents,
whatever you want to do.
but they have not
But
punished.
I'll have to also look into the interest which has now accrued, right? Which has now accrued on the people, maybe illegally. But till that is not put to challenge before me, how can I stall them? They are doing the work.
No, the letter of intent acceptance is also only punishment. No agreement has done till now.
Be that as it may, that is enough. A right has already accrued. Then you file your reply, bring all these things, we'll look into it. Or kuch hai?
My lord, in item number 33, so I apologize for my miscalculation of date. So kindly, instead of 23, make it 20, Friday. The police station, the CD calling in police station in Papunola, so no far distance. So kindly-
23, not before that.
I have already been there 15 days.
You be there. What was the offense here?
Only the molestation, 74 BNS, and Arm Act 25, 27. Below the punishment is 7 years.
23rd, not before that.